Okay, class, we're going to go over now demand letters. You've got your demand letter coming up due, and normally in class we review a demand letter and how to format it and how to put it together. I do want to point out that there are sample demand letters in the resources folders, so make sure you look at those demand letters. I'm going to give you some specific pointers on what to do and how to make it work. So this presentation, it's about 28 slides. We're going to go through some information probably. And if you have questions, email me, but this should give you everything you need to know. Okay. So the demand letter. If you have a demand letter, you need to start with an introduction. Why you're writing them the demand letter. If you don't tell them why, they might be very confused as to what the letter's even all about. Then you have a factual statement, the legal argument, how you're calculating the injury or the damages, and then what you're asking them for. So we're going to go through each one of those right now. In the introduction, it's why they're getting the letter. Tell them who you represent and why you are writing them. Okay, for example, Judas Priest has retained our firm to seek compensation for injuries caused in a car wreck by your insured Frederick Mercury. You tell them what has happened, why you're writing them, who you represent, and then you're going to give them more specifics later on. Okay. Some things not to do. Don't say enclosed please, right? It's just not good grammar, and it also sounds wrong. So don't use it. Okay, try some of these. For example, consider the grammar. Enclosed, please, find, right? These are past participles, needless pleasantry. You don't need to say please. You're asking them for money, right? Find, verb in the imperative form. So just make sure you don't use it. Make sure that you're writing in a way that's very clear. Here's, enclosed please find, a more ridiculous use of words, it seems to me, there could not be. Okay, it's archaic deadwood. Just don't use it. It's not something, people tend to use it because they think it's going to make them sound more formal. But you can be formal without using those terms. All right. Also avoid. Attach, please find. Enclose, herein, please find enclosed. Okay, just skip using those words and write it in a much more simple way. The simpler your language, the more plain your language, the easier it will be to understand. And that really is what we preach in everything that we write in our firm, is write as simply and concisely as you can. So some of these words are going to be completely useless. Factual statement. The factual statement is going to lay out what has happened, why they're at fault, why they're responsible, and why you are injured. Okay? You got to lay out the facts in a way that you tell your story and cite specific facts related to you, what you know has happened. You can include pictures in your demand. Including those pictures will show them the extent of the damage to the vehicles and extent to the damage to the person, showing them that this is exactly what happened, or show them the location of something where it occurred. For example, if it was at somebody's home or if there's blood somewhere, you can show them those pictures. Use words that show confidence and that your client is right. Do not waver in your words. Do not waffle in your language. Make sure you are very confident in everything you say. Tell them they are responsible. And make sure that every way that you describe your story is also showing them that they're responsible. And don't use that legalese, right? We've talked about that many times in class. Sound like a human being. Make sure that you are using plain language, even though you're writing to somebody that probably understands the legalese. Make sure you're writing in a very plain way. That language is much more powerful. And finally, speak from the perspective of the defendant. This is something that is hard to learn, but we're going to go through some examples here. I'm going to show you how that works. But basically, the concept is, rather than saying that your plaintiff, this is what your plaintiff did, this is what your plaintiff did, this is what your plaintiff did, you show from the perspective of what the defendant did. Okay. And what this does is it puts the person, the reader, in the shoes of the defendant, showing the reader all the things the defendant did wrong without even having to put the plaintiff in the picture and tell the defendant did or did not even see them. If they didn't even see the defendant and they hit them with their car, for example, it makes it even worse. So let me give you a car wreck bad example, okay? On or about January 15th, 2015, my client was allegedly hit from behind by your insured, who my client claims was driving negligently. My client thinks that your client was driving way too fast, was not paying attention, was probably texting on his cell phone. Because your insured allegedly couldn't wait until he got home to send his precious message, my client now says he's in agonizing pain. Okay, let me give you a better example of how that might work. On or about January 15, 2015, plaintiff was at a stoplight facing on Charleston Boulevard at Nellis Avenue when she was struck from behind by defendant who was driving negligently. Plaintiff was injured with whiplash and a concussion as a result of the accident. Now, you can see, this is the previous example, you can see that there are way more words here and way too much. It took so long to even get to the point. And you go to this other mediocre example, which isn't the best. We're going to get to a better example later. It uses very plain language. It at least spells it out very simply. It might not be very persuasive, but it is at least better than the first one. Let's get to a better example. On January 15th, 2015, Judith was driving her 2004 Honda Odyssey on the way to pick up her 13-year-old daughter from gymnastics. She was heading west but stopped on a red light at Charleston Boulevard on Nellis Avenue when suddenly your insured, Frederick Mercury, forcefully collided into her from behind with his 2012 Cadillac Escalade. Judith's head whipped back, then forward, and then struck the steering wheel. This example not only makes it concise, but uses specific facts from the case. That is what was missing in this previous, right? This is the mediocre example. A mediocre example is not using specific facts, including what the car was. Why do you think the car matters? Look at what kind of car she was driving, a Honda Odyssey, and what was the other person driving? A Cadillac Escalade. Do you think if a Cadillac Escalade collided into your vehicle, if you're driving a car or a minivan, that it might cause significant damage to you or your vehicle? Yeah, probably will. So that's a very relevant fact that you want to make sure you put in there. So keep note and take note of using relevant facts and making sure that it creates a very clear picture of what you're trying to describe. Some examples. Okay. Now all those were from the perspective of the plaintiff. Okay. So we haven't gotten to the best example yet. It is far more effective to tell a story from the perspective of the defendant, as I said, because it makes someone whoever reads it feels like it could happen to them. And that really is the goal, right? We're trying to persuade people or dissuade people from certain activity. And if you can make them think, hey, this could happen to me or could have happened to me, then they might be more willing to settle in that case. So here's another example. On January 15th, 2015, Freddie Mercury in his 2012 Cadillac Escalade was heading west on Charleston, approaching Nellis at about 45 miles per hour. Freddie's phone buzzed at him, and he looked down briefly to see who texted him. When he looked up, he saw a line of cars stopped right in front of him at a red light. He didn't have enough time to slam on the brakes before he collided with Judith's 2004 Honda Odyssey. Freddie's impact caused Judith's head to whip back, then forward, and then strike the steering wheel. Much more powerful. It shows how dangerous his actions were and what he did to cause this car crash. So try very hard to write from that perspective, the perspective of the plaintiff, the defendant. What they did wrong, and how that could have happened to anybody. Okay, medical damages and facts. Now, you don't just want to lay out the facts of the mechanics of the crash. You also want to tell about the injuries. Prepare the layman's summary of the medical records, right? Tell us what those records mean. Doctors do not write in clear language. It's like the equivalent of legalese, but it's medicalese. And you have to be able to read those medical records and help a regular person understand exactly what they mean. So, in the facts, in some of the facts, we're talking about what happened. You also need to talk about what happened to the person. In the previous example, we had talked about how the person's Judith's head whipped back, then forward, then struck the steering wheel. Then, what happened to her body, right? That's what caused the injury. What was the actual injury? Was there tearing in her muscles, in her ligaments, in her spine? What happened to her? Did she get a concussion? Did her brain bruise? And was there internal bleeding? Those are the types of things you need to describe. And they are very powerful words. You also have to refer to the parties by their names. Don't call the parties plaintiff and defendant, claimant and insured. It is not powerful enough. When you're talking about, call your client by their first name. Preferably, it makes them sound like a regular person, a real person, somebody that they might know. Okay? The opposing party, you definitely want to call them by their name too. Defendant also is not personal enough. If they have harmed and done something terrible to your client, you want to personalize that their actions to them. So you can call them by their first name potentially, but maybe you want to call them Mr. Mercury, which may be the more preferred method, or Mr. whoever it is, or Ms. whoever it was that caused the injury or caused the problem. All right. Eliminate words and phrases that undermine your strength. For example, my client believes that your client was negligent. Well, my client believes. So were they negligent or not? The good example is your client was negligent. There's no belief. Were they or were they not negligent? You're asking them for money. If they're saying, if you say, well, we believe they were, and they might say, well, we believe they weren't. And so you're getting nowhere. Another bad example, your client allegedly failed to exercise due care. No, your client failed to exercise due care. Make these plain, easy statements. Make conclusions. Tell them what they did wrong. Another bad example, the evidence suggests that your client had a duty to act reasonably. Well, the evidence suggests nothing. It is everyone, including your client, has a duty to act reasonably. Everybody does, no matter what you do. Okay. Just some examples. Be sure to be very precise in your language and work on them. One thing I want to recommend to you in the drafts of your complaints, put it together, have a family member, or a friend or somebody that you trust, read it, get their feedback. Do they feel like you told the story in a way that makes them feel like, hey, this something terrible happened here and we definitely need to try to settle this case? If you have, then you've succeeded. Or have them look at your language and ask them whether or not you are speaking clearly and plainly in a way that anybody could understand. Then you know you're getting in the right direction. Okay, legal argument. How you formulate your argument. Well, that's the next part. IRAC. Now, IRAC is issue, rule, analysis, conclusion. So the issue is, there was an injury, should they be paying you the money, right? What is the rule? The rule is that if it's a negligence case, that everybody owes a duty, and if they breach that duty, then they owe you money, okay? But you got to look at what your cause of action is, and that was what the rule is. So the issue is, what is the problem? What are we trying to solve? The rule is, what is the rule that applies to the case? The analysis is taking your facts and applying it to the rule. The analysis, the A, okay, IRAC is an acronym, issue, rule, analysis, conclusion. The A, the analysis, is the most important part. I cannot emphasize this enough, and I will say it many times in class. If your analysis is not the majority part of what you are writing, then you have missed the point. The analysis is where you take your facts and the rule, and you compare those two strongly enough together, stating that our facts apply to this rule, therefore you have to pay us. A conclusion is simply a statement saying that you owe us money. So, analysis is not saying the facts are this, the facts are this, the facts are this. An analysis is the facts are that Bob was driving too fast, which is negligent behavior, right? Because a person should act in the way a reasonable person would. And if they are speeding down the highway faster than the speed limit and swerving through cars, they are not acting in a way a reasonable person would. Do you see that I took the facts and the rule and I matched them together into an analysis? Make sure that you practice that, and this is the best place to start practicing it, because your very last assignment, if you do not write me a good analysis, you will not get a good grade. And that is the biggest part and why most people lose points on the very last assignment we have in this class. So, lay out the law. Again, tell them what has happened, what the law is. The issue is, okay, Mr. Mercury is responsible for Judith's injuries based on a theory of negligence. Okay, that is the issue. So it's not, is Mr. Mercury responsible? No. The issue is Mr. Mercury is responsible. That's the issue. And the issue is that they should pay you because of that. All right? The rule is, what is the rule for negligence, or whatever your case is. If your case is a domestic abuse, it's battery. If it's any one of those things, then you need to know the rule for that. And then you will be learning that in Professor Perry's class, or you'll have to look it up. But then you have the rule. And then you have to apply, see how those are all broken down. Defendant owed a duty of care to the plaintiff. Defendant breached that duty, right? Each one of those is their own specific factor that must be analyzed. Therefore, you have duty, breach, causation, damages, each one of those lines. And so you must analyze each one of those factors. Meaning, going back to the previous slide, did the defendant owe a duty of care? Well, everybody owes a duty of care. So you state in your analysis that defendant was a driver in a vehicle. Drivers of vehicles owe a duty of care to everybody else around them. Because he was the driver of a vehicle, he owed the duty of care to our plaintiff, Miss Whoever. Okay, that is an analysis or a IRAC of that specific one. You do the same for breach. Did he breach that duty? Well, Mr. Defendant was driving too fast. Because he was driving too fast, he breached his duty, because everybody has a duty to drive the speed limit or at the speed of traffic, and therefore he breached his duty. You understand? See how I'm using the rules and the facts, putting them together. This is something you're going to have to practice and fully understand to do well in this class. So this slide again says every single one of those needs to be analyzed appropriately. It doesn't have to be a long analysis, but if you analyze each one, the whole analysis will end up being quite long. And again, applying facts. If there is a violation of a statute, then you give the rule for negligence per se, and then the duty breach elements together. Okay, so always use the facts. Final, computation of damages. In damages, you have to show us how much money they're owed, so you need to break this out. And if you of course, don't have these facts in the little case that we provide to you, so you're going to make these up. Okay, you're going to come up and you're going to tell us the different medical treatment that they received, or what the breach of contract was, and how much they cost them to have to find a new person to perform those services, and what the total injury was. And then you add them all up and you come up with total damages. Most cases there are pain and suffering, so you want to make sure you come up with a number for that. It needs to be a specific number and something that's reasonable. I know we all love to say it's $1 million case, but if their medical bills are only $8,000, you're probably not going to ask for $1 million in pain and suffering. Okay, so stay reasonable with those. Okay, so something like this, some sort of a table like this, will be very helpful for you. Then you have the final demand. It's quite simply a statement that says, we are asking for this much money. This is time sensitive, so respond to us quickly. Okay, 30 days is the standard in Nevada. Well, I want you to use that in your documents as well. Respond within 30 days. If you've done it, all you've done is you told them how much you want. You've already laid out your case before, so you don't need to do anything other than say, this is how much money we want, and this is how much time you have to respond to us. And then you say, then you sign your name. That's it. Okay? Or actually the attorney's name. You wouldn't sign as a paralegal. So that is basically how you are going to write your demand. It is a simple format. It really comes down to you laying out your facts, what the rule, how the facts apply to the rule, what the medical damages are, and how much you're asking for. Demands are used very, very frequently, and so you'll get very good at writing these. This is your first chance to make a really great demand. So best of luck. We'll see you guys soon.